All right. All right. Good morning, gentlemen.
Good morning.
Good morning.
Morning. We're going to go ahead and call court. So if you could do that for us, Ms. Rose.
Court of Appeals for the 8th District of Texas is now in session.
Thank you. And at this time, the court calls Garza et al. Versus RDL Energy Services LP and RDL Energy and JPH Holdings. And may I have, well, I don't need announcement of counsel. I've got Mr. Ballantyne, you're arguing for the appellant, is that correct?
That's right, Your Honor.
And that would be?
That would be the survivors of Ruben Garza.
All right, thank you. Okay, I appreciate that. And then Eric Butcher, you're arguing for RDL, both RDL, and, right? And Mr. Johnson, you're arguing for JPH. And insofar as Mr. Butcher, Mr. Johnson, you've already submitted to the court how your time is going to be allocated?
Yes, Your Honor. I'm going to take the first 12 minutes, and then Mr. Betcher is going to take the remaining 8.
All right. Well, thank you very much, gentlemen. I appreciate that. And just so y'all know, the court obviously has had an opportunity to review the briefs and the record. We've had discussions regarding the case. So if it aids in your presentation this morning, we are familiar along with the facts. So with that, I'm going to let Mr. Ballantyne, you may proceed.
Thank you, Your Honor. And may it please the court. My name is Patrick Ballantyne, and I am here representing by appeal the survivors of Ruben Garza. He was a man that was killed on the side of Interstate I-10 in West Texas in a collision caused by Adrian Samuels. Mr. Samuels was an oil field service worker employed by Appellees who was traveling from his home across the state of Texas and transporting a 7,000-pound work truck for use on the job site by his employers. Summary judgment was granted against the appellants below based on the employer's contentions that they couldn't be held vicariously liable due to the coming and going rule, and that there was no evidence supporting our theory of negligent entrustment. So taking up first the vicarious liability concerns. Your Honor, appellee's position is essentially that an employee may never be held liable for the negligence of an employee while that employee is driving to his workplace. But of course, that's simply not the law. The coming and going exception holds that employers will generally not be held liable for the torts of their traveling employees, and generally means that that rule is by no means absolute. So what is the standard for coming and going these days with regards to the doctrine of vicarious employer liability? Well, as the court is well aware, that standard was recently clarified by the Supreme Court in the Painter case, or what I believe is commonly referred to now as Painter 1. And so to set the standard, the Supreme Court clarified that whether the employee was acting in the course and scope of his employment turns on whether the employee was performing the task generally assigned to him in furtherance of his employee's business. And the court goes on to say that there's sort of a two-part component to that. There is the employee must be first acting within the employer's authority, and secondly, for the employer's benefit. And so the essential question, as the Supreme Court in Painter put it, was the employee undertaking a special mission on behalf of his employer or otherwise performing a service in furtherance of his employer's business with the express or implied approval as employer? In other words, was there some special benefit? This is also sometimes called the special mission exception, but really special benefit is, I think, more appropriate for most of these cases.
Counsel, if I can interrupt you for a minute, are you contending here that there was a special mission I guess, transporting the truck from, I guess, outside of Houston to Pecos?
We are, in special missions sometimes I think sometimes that gets taken as an extraordinary duty. That employee is told to go somewhere and do something while he's on the job site. But what it really is, and Painter sort of clarified this too, it's really just, is there a special, and by special, I think they mean specific benefit conferred to the employer in what the employee is doing when the accident is caused. And so, yes, we are contending that the transport of the work truck to be used on the work site was a special benefit and therefore a special mission conferred by Mr. Samuel to his employer's benefit.
Do we know what time Mr. Samuel was asked to go to Pecos?
The record shows that he was told the day before that he was to report back to Pecos. He got a night's sleep, and then he left towards the evening to drive overnight, leaving, I believe, about 6 p.m.
Okay. For some reason, I thought it was 11:30 when he left, but
Your Honor, it may well be. I know it was in the evening, and the wreck happened in the early morning hours.
but we don't know precisely when he was called and directed to, or asked to go to Pecos.
I know he was called before he went to bed that night, and then went to bed that day. So he got some sleep during the day and then left in the evening, is my understanding. If that's incorrect, I'm happy to clarify post-argument. But what it really comes down to is that when he was called by the JPH supervisor and told to come back to the Pecos work truck, it wasn't merely commuting to work. He was specifically directed as one of the duties of his employment to transport this 7,000-pound work truck. Now, if he was merely using this work truck to drive to and from the work site, I think that would fall within the coming and going rule. But because that work truck was an essential piece of equipment to be used on the job site, and that's clear from both Mr. Samuel's deposition testimony and JPH's corporate representative's testimony, because that was part of his duty to transport that truck, and that truck was to be used on the work site, he wasn't merely commuting, he was actually transporting equipment. And that's the special benefit conferred that takes this out of the mere coming and going employee commuting to work common situation and imposes vicarious liability on the employers in this case.
So counsel, can I ask you how you would distinguish the argument of your opponents that, I mean, these days, almost anything people carry can be deemed a work tool. I mean, if you carry an iPhone, a lot of people would consider that to be a work tool, or me, I need reading glasses. I'm sure the chief wouldn't consider that to place me in the course and scope of employment. I mean, there has to be some way to distinguish just routine items you may find in your car, whether it be work papers or not, from, I guess, what you're claiming here.
There absolutely is. And thank you for asking that question. That is a key distinction that I'd like to address because, yeah, I came here to work today with my laptop and my backpack. If I had gotten in a wreck, I think it'd be kind of absurd for me to stand in front of a court and say that, or for somebody to stand up and say that I should be held liable. But here's what I would encourage the court to do. Go back and look at the whole purpose of the coming and going rule. The coming and going rule recognizes that there are shared risks on the road. That is, all of us out there who are commuting to and from work or otherwise using the public roadways and just assume a sort of risk being on the roads. And that liability when accidents happen shouldn't extend to our employers. And when you are transporting a laptop or any other piece of tangible equipment or items, really that doesn't increase the risk that we have on the road. When you are transporting a 7,000-pound work truck, the risk to the community, to others on the roadways, is increased in a substantial way, not just a theoretical way, in a substantial way. And I say that because in this case, the work truck that Mr. Samuel was transporting was the instrument of injury. It was what caused Mr. Garza's death. And so by asking or directing Mr. Samuel to transport that work truck, the employers increased the risk substantially that we all face on the roads. And that's why that's what brings it out of the rationale that underlies the coming and going rule, shielding employer liability, vicarious liability for employee negligence while traveling. But
so, Mr. Ballantyne, then when did the course and scope begin for Mr. Samuel?
I would say the course and scope began when he hit the road that day. Given that he was directed to transport that work truck to the job site. Now, whether that had been a block or as in this case, several hundred miles across the state, given that the employer knew he was traveling across the state and directed him to show up with that work truck, course and scope started as soon as he left his residence with the truck.
So if an employer, though, like in this case, provides the work equipment to the employee and allows them to take that equipment home with them, then how does the course and scope end?
I think that is a stickier question, because we say coming and going, but there's kind of this distinction between coming and going when you're transporting equipment. If you're merely going home, you're using that truck as a means of commuting. Now, I might still stand in front of the court and make this argument, and it would be colorable, but I think in this case, it's much stronger in that he was directed to take the work truck because it was to be used as soon as he got to the work site in the conduct of his duties. Now, if Mr. Samuel had just decided when he was called to come back to the Pecos work site, you know, I'm just tired of driving that big old truck. I'd rather take my own passenger car. It's much more comfortable. If he had showed up to the work site with that car and without his truck, he would have had some explaining to do. He would have been in trouble because he had not fulfilled a substantial duty that his employer directed him to do. That's the special benefit that he was conferring on his employer, was transporting that work truck, and what takes it out of the mere commuting that we all did to work today, or presumably. I don't know where everybody is actually appearing, but I think post-Painter, the best analysis I have seen by any court, and I'm not just flattering the court here, is this court's opinion in Martinez v. Boone, because it really goes into the factual analysis of what is or what may be considered a special benefit conferred by an employee in the course of his duties on his employer. And I'm not going to go over the facts of that case because I know your honors are all aware of it. But Chief Justice Rodriguez's opinion in that case, I think, is one of the best and most edifying analyses post-Painter of course and scope and coming and going in the third-party liability context. And I think applying that rationale or that analysis to this case, to the facts of this case, the same conclusion must be reached, that there is a genuine issue of material fact and at least some evidence that that Mr. Samuel was not his employers will not be shielded by the coming and going rule, and that they will be at least subject to a factual question submitted to a jury about whether they are vicariously liable for any negligence he may have exhibited in causing Mr. Garza's death. Now, I would like to take a moment to address a case, because I did not address this in our brief, that the appellees have cited. I think it came out after I filed our brief, but that's a first court of appeal, Houston Court of Appeals case called, and I don't know the pronunciation of this name, but it's City of Houston v. Carzarales. And now appellee JPL cites this case as an example of, well, if you're driving this giant work truck coming back to work from a lunch break and you cause some injury, if that can't be, if that is coming and going and that a vicarious liability can't be imposed there, well, then you can't impose it here. But I'd like to point the court to the key distinction in that case. And that's that case turned on the statutory definition of course and scope contained in the Texas Tort Claims Act. It was not the rule in Painter. It was not the common law third-party liability. It was the Texas Tort Claims Act's definition, which specifically asks whether the employee was in the performance of her duties as assigned by the governmental entity when the injury occurred. And in that case, the Houston employee who was driving this large sewer truck said, well, I wasn't performing my duties because all the duties in that truck take 2 employees and I was the only one in the truck. And on that basis, yes,
Mr. Valentine, excuse me for a minute. Can you give us that site?
Yes, I don't know that it's been published, but the docket site is 01-20 -00699-CV.
All right, thank you. I appreciate
Yeah.
that.
And so because that truck required 2 employees and the deposition testimony from the city employee was, I was the only one in the truck, the Houston Court of Appeals said, well, under the narrower definition in the Texas Tort Claims Act, imposing liability on government entities for automobile accidents, this wasn't course and scope. So that's the distinction I would make in advance of the Pelley's argument with regards to that case. Another case they rely upon is Mejia Rosa. And that is also a Houston Court of Appeals case that's cited in, I believe, all briefs, but the docket citation is 01-17-00955-CV. And there we have an electrician who is driving a work van home when he struck and injured a pedestrian in his own parking lot. And the Houston Court of Appeals said that did not fall under the, or that did fall under the coming and going exception to vicarious liability. But importantly to note, in that case, the appellant did not allege, and this is quoting from the opinion, did not allege that the driver was on a special mission or otherwise engaged in a service in furtherance of the employee's business. We have asserted in this case, special mission, special benefit, and certainly that Mr. Samuel was engaged in a service in furtherance of his employee's business.
Counsel, if I could interrupt you for a minute. I want to ask you a question and ask also the appellees to address this as well. Do you draw a distinction between JPH and RDL? Because it seems to me your course and scope facts all focus on JPH, who secured the truck for Mr. Samuel and who directed him or asked him to come to Pecos. Whereas RDL, I'm not sure even knew about that. For some reason, I believe in the record, they had a policy that they were supposed to get permission before one of their people get a vehicle, and maybe it wasn't asked or they didn't give it. But do you draw some distinction between how the summary judgments could play out between those two entities?
We contend that liability to one is liability to both under the joint employer doctrine, and we briefed this both below, and I've also addressed it in our brief on appeal. So the joint employer liability doctrine, and by the way, just to be clear, this is not a independent contractor situation case. This was a borrowed employee case. So under the joint employer doctrine, both the general employer and the borrowing employer can be held liable. And all that is required is for both employers to retain some measure of control over the employee. Now, JPH's control over the employee, I think that's very evident. It's not really in dispute. They did retain control over Mr. Samuel. RDL as an employer, as Your Honor notes, Justice Daly, did retain control contractually over Mr. Samuel. They had the right, well, first of all, they contractually JPH was required to tell them what vehicle they were to be used, Samuel was to be using. They also had the ability to pull him from any job for any given reason. So that's the control they retained. Additionally, they did they assumed responsibility for Samuel's pay, his tax withholding, workers' compensation, insurance, and so on. So we believe that both are liable if one is liable under that doctrine.
So my hesitancy on the control, though, is, I mean, that's when we decided Painter the first time around, we focused on control as being relevant to course and scope because there's a slew of Texas cases that said that, but the Supreme Court has disabused us all of that contention because control relates whether you're an employee or not. Control does not relate to whether you're in the course and scope. So my question is, I mean, how would RDL have placed this man in the course and scope if they never gave him the truck and never knew about the truck?
Well, I think they're two distinct doctrines, and there's a lot of bleed in there. So yes, it does get a bit confusing. But when you look at the joint employer doctrine as a separate developed field of law or doctrine of law, what it basically says is when you have two employees, the employers, the general and the borrowing, liability to one is liability to both. Now they can fight out the issue of apportionment and encounter each other, but both may be held liable under that joint employer doctrine. And so, yes, the control issue that does get confusing because it does come into play under both. Your Honors, I would just take just a brief moment to address our negligent entrustment issue, because I do see that I'm running out of time. So below, the court also granted summary judgment holding that there was no evidence of negligent entrustment. That was one of our theories, unrelated to vicarious liability. So the elements of that are just very quickly that the defendant entrusted a vehicle to a person who was unlicensed, incompetent, or reckless. 3, at the time of the entrustment, the defendant knew or should have known the driver was unlicensed. 4, the driver was negligent on the occasion in question. And 5, the driver's negligence proximately caused the accident. Now, our theory of negligent entrustment is that Mr. Samuel had a long history of reckless and irresponsible decision-making, as evidenced by his very lengthy criminal history, a criminal history that includes having spent at least 12 years in federal prison for possession of over 50 grams of crack. Prior to that, he was arrested and convicted of numerous state criminal offenses for which he served both custodial and supervisory sentences. These included driving while intoxicated, driving while license invalid, felony drug possession, narcotics and paraphernalia possession, burglary, forgery, and larceny. Now,
But I mean, aren't all those about 20 years remote? I guess I'm concerned about the idea that there could never be redemption for someone, and that basically if you have those kind of convictions, you're never going to get a job that would put you in a position of getting a vehicle or having any responsibility.
And I'm not unsympathetic to that argument, Your Honor. I'm a criminal defense attorney, so I believe in second, fourth, fifth chances, as many as it takes. But really what you have here are not just a bunch of remote convictions. You have a pattern of criminal and irresponsible behavior that's pretty much Mr. Samuel's entire adult life. Almost his entire adult life, he has spent engaged in the criminal justice system as a defendant or as an inmate. And the appellees were aware of this. They conducted background checks, and Mr. Samuel testified that he disclosed his whole criminal and driving background to them. And so, Your Honor, I don't know if that's negligent entrustment. Maybe it is, maybe it isn't, but it's at least enough to submit that to a jury, because it is at least a scintilla of evidence that they negligently entrusted a 7,000-pound work vehicle to a man with this history of life irresponsibility. Thank you.
May I present, Your Honors?
Please, thank you.
I'll start really very quickly and briefly on the negligent entrustment, since that's where we ended. There's no law in Texas, no case that they cite where over 2 decades separated, there's any case where unrelated crimes were held to support a claim for negligent entrustment. Here, the accident was caused when someone fell asleep. A 25-year-old DWI conviction in no way would be proximate cause or foreseeable that could occur 25 years later. So the court was clearly correct in granting summary judgment as to negligent entrustment. Getting to the vicarious liability aspect, I'll start with Justice Alley's question, and is there really any kind of distinction here between JPH and RDL? From JPH's perspective, it doesn't matter. For purposes of the summary judgment, we went ahead and we're assuming that we're the employer at the time, which is kind of what happened in Painter. I mean, that was the whole purpose of Painter, is when someone is an employer that's known, you don't look at the task-based analysis approach. You skip straight to the was it in furtherance. So I think that answers Justice Alley's question. I was surprised for a couple of things that we just heard, and that's that they're now claiming that it was a special mission somehow. That's not in their summary judgment response. That's not in their briefing on appeal. So I was a little surprised to hear that. I was also surprised to hear that, as a factual assertion in this case, that Samuel was called by JPH and directed to bring his work truck to the site the next day. There's no evidence where he was called up and told, hey, we need your work truck here, please bring your work truck. What the evidence shows is, in just like almost every employer-employee situation, he was called, he was at home for several days on leave, without doing any work. And he was called and said, you report next day, you have work, just like any other employee. He was given a truck, a company car, a work truck that he used to commute back and forth. But what it was used for is when he got to the site, he's a hydro test technician that tests pressure in pipelines. He drove back and forth between sites. That's what the truck was used for. What Painter made clear is course and scope hinges on an objective assessment of whether the employee was doing his job when he committed a tortious act. And there can be really no serious argument that when Mr. Samuel was driving his truck from Rosenberg to Pecos, he was doing his job. He was doing something for the accomplishment of the objective for which he was hired. He was simply driving just like everybody else on the road. And that's the main purpose of the coming and going rule, is traveling on public roads is a shared risk by members of the general public and not one that is ordinarily incident to employment. He was simply just driving to work at the time. It wasn't like Painter where—
Mr. Johnson, then are you saying this is just an ordinary commute?
Right. This is just an ordinary commute for, it's for someone who lives in the oil and gas or works in the oil and gas industry, where they come and they have several weeks on and several weeks off, and they live all over Texas. And in this situation, it's not like Martinez, this court's opinion, where the court specifically found there were facts where the driver's employees instructed him to drive 65 miles away, pick up supplies, and drive back. That is a special mission.
So if it's just an ordinary commute, then why is he paid and compensated for travel time and fuel costs and other things?
Sure. And that runs the gamut of so many different cases. There's so many cases out there that have held that when someone is on the clock, and in this situation, he got his daily pay. Every day that he's going to work, he gets his daily pay, and he was on his way to work that day. But there's case after case, Your Honor, that specifically have held that, fuel, vehicle allowances, mile reimbursement, per diems, compensation for driving, and being on call while driving are simply not enough to equate to you're actually doing something in furtherance. Because it's not just were you getting paid, it's were you actually, from Painter, were you doing something in furtherance of the employer's, the reason for employment while you were driving in? And I would point this to the Carrizales case that opposing counsel mentioned that we cite from the First Court of Appeals. In that case, the worker was on the clock all day long, was driving a work truck with a 1,000-gallon tank on it for blasting out sewer clogs, and was coming back for lunch on the clock. And in that case, the First Court of Appeals held no, the coming and going rule still applies. And while that case was a Texas Tort Claims Act, that wasn't dispositive of any of the rationale for that. And the court cited general non-governmental immunity cases for that proposition. And I would note that case was taken up to the Supreme Court, and the Supreme Court denied PET without even asking for a response in that case. And as I stated in our brief, surely if someone driving a truck that's been specifically modified for blasting out sewers and was on the clock is not held to be within the course and scope of their employment when driving back from lunch, the same rule should apply here. And for the same reason, the Mejia case that we cite, it's a electrical van that someone uses to go from site to site to perform electric services.
So where's that point in time in this case when the employee begins the course and scope?
Sure. And in this case, it would be when when Mr. Samuel showed up at the site. That's when he begins his work. He was called to show up at the site the next day by 7 a.m. That's just like any other employee situation. This morning, when I drove into work, I was not in the course and scope until I showed up in the parking garage and walked up to my office. Even though I use my car all the time to go back and forth between hearings and depositions and stuff. What matters from the coming and going rule, are you going to work? Are you coming home from work? And in this situation, he was going to work. It's undisputed. He was simply going to work. There was nothing else he was doing in furtherance of his employer's duty as he was going to work.
Does it make a difference, though, that he was asked to show up basically halfway across the state at 6:30 or 7 in the morning, and his employer knew that he was going to be driving kind of in the dead of night, and there's some nexus between falling asleep, that is driving at those hours. And then it's at least alleged that he fell asleep and that was the cause of the accident. I mean, that seems a little different than somebody going to lunch and coming back to work.
I hear what you're saying, Your Honor. I just don't agree that there's a distinction there. That's the nature of this work. That people, all over Texas that work in the oil patch live all over Texas, drive home for several weeks or several days, and then are called to come back out and work. And in those situations, they're often traveling 3, 4, 5, 6, 7 hours. And a lot of times they are driving overnight. The Supreme Court has found that there is no duty for employers to monitor their employees when it comes to fatigue. So in this situation, it was up to the employee, Samuel, to get his rest if he was going to make an all-night commute. And it sounds like he did. I don't think that's really any different than if I was in the middle of trial and I left the courthouse after a jury charge conference at 11 p.m. and drove home. I'm still going home at that time, especially if the courthouse was in West Texas and I was driving 6 hours to go back to Houston. I'm still not within the course and scope of my employment. I'm driving home at that time. So I hear the point you're making, Your Honor. I just think that would mean that almost every hand in the oil patch then that's driving into work would be in course and scope just because of the distance between where they live and where they work. And I don't think that there's any case law that makes that distinction. I really can't emphasize enough the importance of the Caravales case, just because I think it sums up the issues here so nicely. They were on the clock at the time where we weren't on the clock, but there was some day pay for this. And it's certainly a work truck that was used in that case, a specially modified work truck. Here it was just a normal F-350 that he drove in. So I also point the courts again to the Mejia Rosa case, where it's a actual electric van that's being driven home. I would also like to point this court to its own opinion, Garcia versus City of Houston from 1990. It's 799 Southwest 2nd 496. In that case, there was a Mr. Smith, the employee, that was provided by the City of Houston a vehicle to use in his employment at Hobby Airport, and he drove that vehicle home. It was a vehicle that he was going to be used when he showed up to work at Hobby Airport. The court held that when he got in an accident on his way to work, that's the coming and going rule, notwithstanding the fact that that was a work truck a vehicle given to him to use in employment. And this court cited a Longoria versus Texaco Corpus Christi case in that, where the court held and this is quoting from the opinion, the fact that the employer was interested in having the employee use its vehicle to go to and from his home did not raise a fact issue as to the scope of employment. So I think the common law is very clear in this situation. So if you have a vehicle and you're driving it to and from work, unless there's a true special mission, which is not alleged here and doesn't exist, it's not within the course and scope. And
so, Mr. Johnson, can I ask you then, did Mr. Samuel have a choice to where he could choose to drive his own personal vehicle or drive the truck?
I'm not sure that that's in the record, Your Honor, and to be honest, I don't know.
Well, but isn't the argument here that in the record his employer intended for him to bring the truck?
Right, and that's a lot like the case, the Garcia case or from this court that I just cited. The City of Houston provided the employee a truck to use, or a vehicle to use when he showed up at work. Here, yes, this is a company car. Companies all over Texas provide their employees with company cars, company trucks. Police stations or police departments provide officers with police cars. But in those situations, that does not take it out of the coming and going rule. The coming and going rule still applies. And as Painter said, what matters is it hinges on an objective assessment of whether the employee was doing his job when he committed the tortious act. And in this situation, all Mr. Samuel is doing.
Well, I guess that's what I'm asking then. If he had just decided to drive a different vehicle, his own vehicle, would he be subject to discipline because now he's arriving unprepared for work?
Yeah, perhaps, Your Honor, I don't know, but not maybe in the same way that if I showed up to work without a laptop or my cell phone or my O'Connor's books or anything and just sat there not doing anything, my boss wouldn't like it. It was, and what you just said makes sense because the discipline wouldn't occur until he showed up at work without being prepared. That has nothing to do with what was going on while he was driving to work. And I see that my time is up.
Thank you.
So, may it please the court, Eric Betcher for Applebee's RDL Energy Services LP and RDL Energy Services LLC, whom I'll collectively refer to as RDL. And RDL is the staffing firm that placed Samuel with JPH as a hydrotest technician in Pecos. And responding to Justice Alley's questions before, for purposes of today's appeal, RDL is situated the same as JPH with respect to plaintiff's vicarious liability claim. And that's because in moving for summary judgment, RDL specified that it didn't matter whether Samuel was its employee at the time of the accident, because he in any event would not be within the course and scope of his employment. So I'm going to discuss the vicarious liability claim against RDL, but first I'd like to discuss the negligent entrustment claim, where RDL is slightly differently situated than JPH. As Mr. Johnson explained, the trial court correctly concluded that summary judgment was appropriate on the negligent entrustment claim because there was no evidence that Samuel was an incompetent or reckless driver. In addition, a separate ground supported the trial court's grant of summary judgment to RDL on the negligent entrustment claim, in that RDL did not provide Samuel with the truck or have a right to control the truck, which is another element of negligent entrustment. So there's no dispute that RDL did not provide the truck to Samuel, and the undisputed evidence also shows that RDL did not have a right to control the truck either. The service agreement between JPH and RDL expressly provided that JPH was responsible for assigned employees' use of vehicles while on assignment, and more generally, that JPH was to supervise Samuel's work while he was on assignment. In the deposition testimony in this case confirms that this is how it actually played out. JPH's corporate representative testified that the truck was under JPH's control, and the witnesses testified generally that JPH exercised control over Samuel's work while he was assigned to JPH. So this all establishes that RDL did not provide Samuel with the truck or have a right to control the truck, and that the trial court's grant of summary judgment to RDL on the negligent entrustment claim was also correct for that reason. So unless the court has any questions about the negligent entrustment claim, I'd like to turn to the vicarious liability claim against RDL and address some of the points the court had raised earlier. And
If I could interrupt you, I have kind of another procedural question.
sure.
So he was driving a vehicle that was provided to him, and he was on the clock. So that gets that Robertson tank line presumption that he's within the course and scope, which you can obviously rebut. But once you rebut it, doesn't that kind of take us out of the no evidence motion for summary judgment? Because now you've had to offer evidence to rebut the presumption. Now, aren't we really only going to be focused on the affirmative traditional motion as to whether both defendants have shown that there's no genuine issue of material fact as to his employment status or his course and scope status, excuse me.
Sure. So that's a very interesting procedural point. As Your Honor pointed out, once the presumption is rebutted, the fact that the employee is driving an employer vehicle is no longer evidence at all for the plaintiff. And the fact that maybe the employer has to point to a piece of evidence or two to show that the employee is not within the course and scope of his employment, whether that takes it out of a no evidence motion or not, I'm not sure. I think that we're confident that whether it's a no evidence motion or a traditional motion, the record conclusively shows that Samuel is not furthering any job duties or furthering RDL or JPH's business when he was driving the truck. So the presumption is rebutted, and that's not evidence to survive summary judgment. And as Your Honor has pointed out about this presumption, there have been decades and decades of vicarious liability cases where an employee is driving a company vehicle at the time, and not a single one has held that the employee is transporting equipment for his employer or that this is a special mission of some sort. It's just the usual presumption that they're within course and scope, and that can be rebutted and vanishes completely when the evidence shows that the employee is not performing job duties. And here, Samuel's job duties were hydro testing pipeline in the Pecos area. That's it. He wasn't hired to drive between Pecos and Rosenberg. He wasn't hired to drive back from Rosenberg to Pecos. And he wasn't pressure testing pipe during that time. So I think that gets us, defeats the presumption and conclusively shows he was not performing job duties at the time of the accident. And it was a large truck, but I would point the court to, I first of all point out that no Texas case has emphasized that before, so that makes any difference. As Mr. Johnson explained, the van in the Mejia Rosa case out of the 14th Court of Appeals was a large electrician van that hit the employee or hit the plaintiff in the employee's parking lot. No one there said that that was different because it was an actual instrument of harm. This isn't any kind of a different situation here. And in regard to something Justice Palafox asked about Samuel being required to bring the truck back, I think this is different. It's a different situation if he was required to bring the truck home to perform work duties and he was performing work at home and then he necessarily, as part of the employer's directive, had to bring it back. Here, he took the truck home solely at his own personal choice, the matter of his personal convenience. He wasn't directed to do that. He was merely allowed to do that. So it was his personal business taking it home and his personal business bringing it back. RDL and JPH's services weren't furthered by him doing that. It was just an accommodation to him. And I'd also like to touch on the special mission point. As Mr. Johnson explained, that was not argued in any of the plaintiff's previous papers. But in addition, I think plaintiff has explained a overly broad conception of special mission. As the Painter case, Texas Supreme Court's Painter case explained, there's basically two cases that it relied on in establishing what special mission is. One is the Pilgrim case out of the Fifth Circuit, where the Fifth Circuit said that under Texas law, to be a special mission, the employee must be doing something more than simply making his services available at the employer's place of business. And that's what Mr. Samuel was doing here. And second is this court's opinion in Chevron v. Lee, where an employee was usually worked at a factory, but on his day off was directed to travel to Midland to attend a special seminar or conference. It's something he had never done before and wasn't just a normal commute from one place of work to the other. And here Samuel had made this commute between 10 and 15 times in the 3 or so months he'd been placed with JPH. So it's a longer commute, but under the Pilgrim v. Fortune drilling case, which was a 3-hour commute each way, that doesn't matter, and it doesn't change the fact that the employee is still just making his services available to the employer at the place of business. So I see that my time's running out, so I respectfully request that this court affirm the trial court's grant of summary judgment to RDL.
Thank you. Mr. Ballantyne, rebuttal.
Thank you, Your Honor. Briefly in rebuttal, with regards to the negligent entrustment issues, now, appellee contends that the DWI conviction is 20 years remote and therefore we just can't consider it. Well, I disagree, because what we're talking about is the scintilla of evidence as to whether the vehicle was negligently entrusted. So whether it's too remote is not the question. It's not too remote as a matter of law. It constitutes some evidence. And so therefore it should be considered. But more than that, it's not just the DWI, it's the history of poor decision-making, of irresponsibility, of recklessness that Mr. Samuel exhibited his entire life, up to and including serving 12 years in federal prison for possession with intent to distribute over 50 grams of crack, that really creates the question that should be submitted to the jury of whether the appellees were negligent in entrusting him with this vehicle. Concerning the course and scope argument, counsel for JPH said that this is just an ordinary commute and it's undisputed that he's simply going to work. Well, I understand counsel's thrust of argument here, but that is the core of the dispute here. He was not simply going to work. He was transporting a piece of work equipment. Now, counsel says that this was to be used to drive back and forth from job sites. It's not exactly right. the testimony from Mr. Samuel, which we quote in our brief and appears in the record under Clerk's Record 349 through 350, says that he would use it to haul material and equipment between the job sites, Your Honor. So he wasn't just using it as a means to commute to and then between the job sites. It was a piece of equipment that was used in furtherance of his employee's business. And now that leads me to my last point in rebuttal. Concerning special mission, we didn't use the phrase special mission a lot because in my mind, that implies that someone was told specially to go do something, sent on some special errand or something like that. But what it really means when you read it in the context of these cases, and I'll briefly quote from this court's opinion, quoting Painter, an exception to the coming going rule applies when an employee is undertaken a special mission at the direction of his employer or is otherwise performing a service in furtherance of his employer's business. So that is what we have argued below and on appeal, is that what he was conferring or what he was doing was acting in furtherance of his employee's business, and the transportation of this work truck to the job site, from his home to the job site, when that truck was to be used on the job site. And that confers a benefit upon, yes, Judge.
Mr. Valentine, excuse me. So let me ask you, is there any evidence in the record that that the company benefited or the employers benefited by virtue of the fact that he would store this work truck off the premises, and that is for safekeeping or safeguarding the truck would, so he took it with him, or is there any evidence to indicate that there was no parking or storage facilities for this piece of equipment and safeguarding it on site?
The record does not speak to that, Judge. I really the benefit that we're contending was conferred was when he was bringing it to the job site to be used on the job site. So it wasn't merely a commuter vehicle that was provided. There would have been a lot more sensible vehicles to be provided if he was just commuting across the state, much more efficient vehicles. But they gave him an F-350 work duty truck because when he got there, that truck was to be used in furtherance of the employer's business.
Thank you.
And so that's our condition in that respect. If the court has no more questions of me, I'll conclude by just saying that
Can I just ask you then, looking at Painter and our task, which is to perform an objective assessment, just could you summarize for us what you believe are the objective factors that we should be looking at in this circumstances to decide course and scope?
Yes, and this case is actually fairly simple in that respect. So as I've argued ad nauseum to the court, the essential question is objectively, was Mr. Samuel in transporting this work truck from his home, regardless of whether he used it to come back and forth, if he had just used it to commute and stop there at the job site, gotten out and performed his job, when he was done, got in and got back home, well, that would be coming and going. So the objective fact that the court needs to I believe, focus on is whether that truck was being transported to the job site for use on the job site, and therefore in furtherance of his employee's business. Now, there are other factors that the court takes into account, and we see this in the analysis that was conducted in Martinez v. Boone concerning was he being paid? Was he on the clock? Was the vehicle provided was his gas provided? Was the insurance provided? All of those are, I don't think, in dispute. His employers provided all of those things for him. So those factor in, and any one of those kind of collateral facts, I don't think would be dispositive of the course and scope issue. But in conjunction with this, I believe, dispositive fact that he was transporting the work truck, I think those are the objective factors that the court should examine. And when the court does examine, I believe we'll find that there is a genuine issue of material fact and at least some evidence that Mr. Samuel was acting in the course and scope of his employment when he caused the death of Mr. Garza.
So go ahead.
I'm sorry, Mr. Valentine. So in terms of the timing of him going, should we draw any kind of an inference that the employer needed him, not so much him, but needed that work equipment at a particular time? So that's why he was driving at that particular time.
Well, I think the inference to be drawn is that when his JPH supervisor contacted him and directed him to come back, it was understood that he would take this work truck to the job. Now, his supervisor, Mr. Samuels testified that his supervisor knew where he lived. He knew he lived on the other side of the state. He knew he was in possession of this truck. And when he directed him to return to work, the reasonable inferences to be drawn is, hey, we need you in that work truck to get back to the job site and do another day of work.
And remind me again, what time was he required to report to work in the morning?
I believe it was about 6:30 in the morning. It
Okay,
was.
okay. All right, thank you.
And so my question, some of the equipment or company car cases that the other side has cited are cases where somebody had the vehicle and then they like went to lunch and they're coming back from lunch. So they're bringing the company vehicle or the truck back to the work site. So what's the difference in those cases, which are they usually talk about it as being a diversion, as distinct from somebody being at home and bringing the work truck to the work site?
Well, the going to lunch case, I believe that's referring to the city of Houston case, and that's just a different standard to be applied. Now, the standard in that case was the employee actually performing a duty when imposed by the city when she was in the accident? And the evidence in that case, she testified affirmatively, I was not in the performance of the duty because that truck requires two people and I was the only one in it. And that was what the court based its final decision on course and scope on. So, I also think in the Mejia-Rosas, I said earlier, and I do think this is a distinction, and I don't know where these lines are drawn, but there is a difference between coming and going when it comes to hauling work equipment. Now, Mejia-Rosas, he was, or the driver in that case was going home from work, and he was driving his work van because his employer allowed it to take it to and from work. But in driving home, he was not conferring a benefit on his employee at the time, on his employer at the time of the accident. Mr. Samuel, by contrast, was conferring a benefit on his employer by transporting this work truck to the job site. So I think, like I may have mentioned earlier, this would be a harder sell if he had injured somebody on the way home. But the fact that he injured somebody on his way to work, I don't know if there's a bright line to be drawn there, but I do think it's relevant to the analysis.
And his name is on the judgment, and I think his name has kind of gotten on the pleadings in our court, but he's settled and he's out of the case, correct?
That's correct.
There's no need for him to be considered in this case at all, correct?
That's correct. His negligence will obviously be an issue, but his liability is settled. And with that, Your Honor, oh, yes.
No, I don't have any further questions unless you have further argument.
No, Judge, I would just ask the court that because the evidence submitted showed that Adrian Samuel was not merely commuting, but actually transporting equipment for the benefit of his employer, there is a genuine issue of material fact and at least some evidence as to appellee's vicarious liability for Mr. Samuel's negligence. And additionally, Mr. Samuel's criminal history, as detailed in the record, does provide some evidence supporting our theory of negligent entrustment. We would ask this court to reverse the summary judgment of the trial court.
All right, thank you, gentlemen, for participating in our conversation today. It's been very helpful in illuminating and answering our questions. And so this case will be submitted to the court today based on your presentation, the briefs and the record. So thank you so much. We appreciate it. Y'all have a good day.